प्रेस कॉन्फ्रेंस शुरू हो गई। मिस्टर त्यागी अपनी बात रख रहे हैं।
Coming to the important issues which are discussed in today's meeting, this press release I believe has been circulated, but some of the important ones I like to highlight. The first one is KYC requirement for FPIs. This is the reference to Sebi circular of April 2018 and subsequent recommendations of Khan Committee. So they were discussed, and broadly it was agreed to amend the circular and the regulations, largely in line with what Khan Committee has said, and that revised circular will be issued very shortly. Second item was on the total expense ratio of mutual funds, and as you know that mutual funds have grown by leaps and bounds, and their AUM as on August 2018 end has actually crossed 25 lakh crore. What has been felt is that while AUM has grown multiple times, the benefit of economies of scale has not been fully shared with the investors. With this broad issue, the proposal was taken to MFAC, and recommendations of MFAC have come, and largely again in line with MFAC recommendations, this proposal was discussed and approved. And the guiding principle being that for sharing of economies of scale, lowering the cost for mutual fund investors, bringing in transparency in appropriation of expenses, and reducing mis-selling and churning. And accordingly, proposals have been approved, and the same have been shared in the press note with you. Third item I like to mention is reducing the timelines for listing of issues. This, if you recall, earlier it used to be T+12, that was reduced to T+6, and now board decided to reduce it to, in principle, to T+3. And using the UPI interface, and with, of course, SBA remaining the concept as it is. So this will benefit both issuers as well as investors. Issuers will have faster access to capital raised, thereby enhancing the ease of doing business, and investors will have early liquidity. The modalities will be worked on in consultation with shareholders, and it will be implemented in a phased manner. Next, I would like to mention about framework for enhanced borrowing by large corporates. You would recall this was a budget announcement for this year, and this is basically with a view to giving a nudge to large borrowers to go towards bond market. This is one of the proposals for deepening of bond market. So this should not be seen in isolation. This should be seen in consonance with various other measures which have been taken in the last few years by Sebi and also by RBI and government. So as far as this proposal is concerned, the eligible borrowers, the large borrowers, the way they have been defined, it's very much in line with what was said in the consultation paper. Just to recapitulate, outstanding borrowings of 100 crore and above, and credit rating of AA, and which they intend to finance itself with long-term borrowings, which defined as more than 1 year of borrowing. As for the compliance for the first 2 years of implementation of the framework, this is proposed to be implemented from 1st April 2019. So for financial year 19-20 and 2021, it will be on comply or explain basis. And this is basically to give them some time to get used to the concept. And from 21-22 onwards, the requirement of 25% incremental borrowing by such borrowers through bond market shall be tested for continuous block of 2 years, and there will be a penalty in case of there is a deficiency in this. Next item I like to touch upon is participation of eligible foreign entities having actual exposure to Indian commodities market in the commodity derivatives market. So this is the first step for opening the commodity derivatives market to the foreign participants, and the board approved the regulatory framework for permitting foreign entities which have actual exposure to commodities market in India to participate in the commodity derivatives market, domestic markets in India. It defines concept of eligible foreign entities. This issue has been under discussion as to whether institutions should be allowed in commodity derivatives market, and at what pace or in what phase. And earlier the discussions have been on FPI, where they should be allowed. Then there are issues of without underlying exposure that may be speculative, And so this proposal has come about after having discussions with RBI and Ministry of Finance. And what has been decided is that they will be allowed to trade in all commodity derivatives traded on Indian exchanges except those contracts having underlying commodity defined as sensitive commodity in terms of Sebi circulars. And tenor of the hedge should not be greater than the tenor of underlying exposure. This may be reviewed based on experience of EFE participation. The benefits of this obviously are discovery of current global benchmark prices for some key commodities which are traded only in Indian commodity derivatives exchanges would get strengthened by participation of foreign entities who have import-export business with India. Participation by such entities could make Indian commodity derivatives market more liquid and efficient. It may also add depth and liquidity in the month contracts. Next item I like to highlight is interoperability among clearing corporations. For that, amendments required to the security contracts regulations, stock exchange clearing corporation regulation. This is also a concept which has been under discussion for quite some time, and it was discussed and board approved the proposal. And interoperability among clearing corporations provides for linking of multiple clearing corporations. It allows participants to consolidate their clearing and settlement functions at a single clearing corporation, irrespective of stock exchange on which the trade is executed. It is envisaged that interoperability would lead to efficient allocation of capital for market participants, thereby saving on cost as well as provide better execution of trades. Sebi shall carry out necessary amendments to SCCC regulations and issue necessary circulars, guidelines, inter alia, including inter-clearing corporation margins, inter-clearing corporation settlement, inter-clearing corporation collateral, default handling process, dispute resolution mechanism, and certain technology-related issues. Next item was on proposed Securities and Exchange Board of India settlement proceedings. This, we had set up a committee under Justice Dave a few months back to have a relook at the consent mechanism. This is basically with a view to have effective enforcement. This is linked with that, and to see whether it needs rationalization and what all could be considered for consenting, and so that Sebi could focus its attention on important and crucial cases, and it should be seen as a credible action for serious cases, and it should not be, time should not be wasted on the cases which are of smaller nature, and also the cases which could be consented. So broad salient features of these regulations are that board, it is principle based as compared to the earlier regulation, and board may not settle any proceeding if it is of the opinion that alleged default has market-wide impact, loss to investors, or affects the integrity of the market. So this is the guiding principle on which it will be decided whether a case is settleable or not. Then again, board may not settle any proceeding where the applicant is a willful defaulter, a fugitive economic offender, or has defaulted in payment of any fees due to penalty imposed under security laws. A new provision dealing with settlement with confidentiality to any person who provides material assistance to the board in its fact-finding process and proceedings has been specified. So there will be a separate procedure with less penalty for the people who assist in fact-finding process. That is a new clause or new mechanism which is being suggested. And also, board shall not consider an application for settlement if an earlier application for the same alleged default has been rejected. Now, the other item is amendment to Sebi PFUTP regulations and Sebi PIT regulations to implement the recommendations of the Committee on Fair Market Conduct. You would recall that last year we had set up a committee under T.K. Vishwanathan, ex-Union Law Secretary, on this issue, and it looked at both these regulations, PFUTP and PIT, and made certain suggestions. So those were discussed in the board meeting and were agreed to with few not changes but with few clarifications. And the important one, of course, is that on the issue of use of front entities or mule accounts for engaging in fraudulent transactions and related recommendations on affordability index, it was decided that this matter needs further discussion with stakeholders. On the issue of additional disclosures considering public comments, the proposal for disclosure of name and PAN number or equivalent identification of persons residing at the same address as the designated persons for a consecutive period of more than 1 year, and disclosure of phone, mobile, cell numbers whose billing address is residence address of the designated person, this was dropped. And on the recommendation that Sebi may seek direct power to intercept calls and electronic communication under the Telegraph Act, since this authorization is to be considered by the government, it was decided that the matter may be referred to the government for taking an appropriate view. Next item is common application form for FPIs. So this, in fact, Sebi has been spearheading for last almost 1.5 years with RBI, CBDT and DEA, and a common application form which has been recently notified by the government has been now brought in, decided to be brought in the FPI regulations of Sebi. And this common application form will deal with FPI registration with Sebi, permanent account number with Income Tax Department, KYC for opening bank account and demat account. So this will be common application form. Otherwise, this was happening sequentially and taking it a lot of time. So this is with a view to having ease of business for FPIs who intend getting registered in India and initiate trading. So there are various other decisions also which are mentioned in the press notes, but I thought I will highlight some of the important, which I feel are the important ones. So thank you, and now the floor is open for questions.
Ankur Mishra from Business Television India. Was there discussion on extended trading hours, and is there any meeting called in a week or so with all the stakeholders by Sebi?
So there was no discussion on extended trading hours. And I just want to clarify on this that we have issued a circular enabling. The important thing is that it enables that from 1st October 2018, it is enabled. But the issues of discussion with the stakeholders is for the exchanges to come back to Sebi with a complete proposal. And that includes discussion with the stakeholders and risk management issues, settlement issues, what will be the different slabs in which, if it has to be from 9:15 to 11:55, it will be in how many periods and all. So those details are still to be given by the exchanges, and as and when they give, then we will consider. So it is 1st October is the enabling date. It is not a target date, and complete proposals have not come to us, and this matter was not discussed in the board.
Mr. Tyagi, as far as the revised circular for KYC requirement for FPIs is concerned, you said that it will be soon issued separately. If you could give us a sense of to what extent...
So it is largely we have agreed with what Khan committee is saying. Let me say that.
So how will you deal with the fear of alleged money laundering and that route being misused for...
So that's why I'm saying that it will be issued separately, because you also know that you have to see the details. So broadly, it is in line with Khan committee. I'm saying that, and you just wait. It will soon come. The circular will soon come.
The Justice Dave committee also. That's also a very important aspect. And you have considered some of their recommendations for reviewing the entire consent mechanism. The Justice Dave panel had recommended widening the scope of the consent mechanism, and in certain cases they have said that maybe certain serious market violations like insider trading and a few others may also be considered. Just wanted to get a sense whether the board today has considered serious market violations like that also to be kept eligible for consent on a case-to-case basis.
No, it is actually, that's what I said. It has gone on principle based, so which has market-wide impact, which impact large number of investors, rather than pinpointing which type of wrongdoing or offence. So it is in principle based rather than saying in black and white that this will not be done and that will be done. So that is the difference.
That's the guidance.
Yeah.
Okay.
Chairman sir, Yash here from CNBC. First question as a follow-up to the extended trading hour. Of course, there was an enabling provision from October 1st. We understand that, of course, brokers have also reached out to Sebi, expressed their concerns. Have they sought any sort of time extension from that October 1st, or is it permanently deferred as far as extension is concerned?
No, one by one. You can ask the second question. I'll answer this first. First, I am saying there is no deferment of that, and there is nothing. I am saying it is enabled from that date. Now, exchanges have to come to Sebi with a proposal which is self-contained and contain all the issues, operational guidelines, how will actually it will work, and also in consultation with the stakeholders. Those brokers are registered with the stock exchanges. So, if a complete proposal is not there, what does Sebi approve by 1st October? There is no question of deferment or not deferment.
What is the stand which brokers have taken? Have they sought?
No. Sought means I am already clarifying that if a complete proposal is not before us, what view can be taken? So let complete proposal come from the exchanges, and then we'll take a view.
Sir, as far as the KYC requirements for FPIs are also concerned, of course, the first time when the draft had come out, there was a requirement of going back and having a further consultation. So in the first go, were there serious loopholes in terms of what you've received in terms of the consultation from the committee now? And could this have been done in the first go itself? Were these that serious?
So I'll tell you what. You know that Sebi has a system of wide consultations, and the intention of the circular was never wrong. No one has said that. And that time actually it was perceived that it's a PMLA related issue. So if something is under parliamentary law and which is not within the purview of Sebi, so it was perceived that perhaps there is no need for consultation. PMLA is something which must be implemented. So there was one confusion which actually broadly I must say and admit that it was that for beneficial ownership under PMLA there is a definition of beneficial ownership. That was clarified by Department of Revenue when it came to our notice. Our suo moto we gave it to Khan Committee. No one has asked us to give it to the Khan Committee. We took up with Department of Revenue as to what is their view, and then they clarified that PMLA definition is for KYC purpose, for reporting purpose, and as far as the eligibility is concerned, concerned regulator could take a view. So that's how it started. There was no intention of not having consultation. Earlier it was, if I may admit, it was simplistic to assume that it is PMLA and should be implemented. So that we realized, and we realized well in time. When we gave it to Khan Committee, we extended also till December. So we gave time, we knew it will take time, and now we have come to some broad conclusion. And PMLA, FEMA related issues are very complicated. It's not something, so it's not purposefully done. It was done under the bona fide assumption that it is a PMLA related issue. So I hope I am clear on this.
So this is a wish from Manila. And I want to know about the corporate governance in Infosys. There have been a lot of reports and prepared, and the reports are not available for the common shareholders. For example, the severance package given to Rajiv Bansal, CFO, there was a report. And what was there in the severance package? Why he was given 17 crore rupees for the severance package? We never know. So what Sebi can do in this matter?
So that whatever action Sebi was to take, Sebi has taken, and but that is we examined it. It is internal matter of the company, and whatever action we needed to take, we have already taken. So right now we are not examining any of those issues.
Sir, this Palak from Business Line.
Sir, in this consent mechanism, you are saying that cases with market-wide impact will not be settled. But sir, this market-wide impact has not been defined or hasn't been defined. I mean,
no, you yourself say, can it be defined?
So exactly.
It is not.
Leave it open for interpretation of
No, but then if you try to straight jacket is that PFUTP will not be done, and if it is a very simple, small sort of a fraud, of say 1 lakh or 2 lakh, and you put your enforcement mechanism with few thousand cases pending in Sebi, that also doesn't make sense. So it will be a difficult call. So that's how we appointed a judge, retired judge of Supreme Court, to actually guide us as to how to proceed. So both ways there is a problem. So but ownership is of Sebi. So don't worry, in case there is any issue, ownership is of Sebi, but market-wide impact, market integrity, large investors getting affected is, to that extent, is to be decided. And if you straitjacket the wrongdoings, that also has its own problems.
Just one more thing.
High-powered committee will take it. Yeah.
Yes, Mr. Barwa, you want to say that?
Yeah, no, as we know, as per the mechanism, there are two committees, internal, then high-powered committee.
Okay.
So they will take a call on that.
So, but there won't be various kind of interpretations.
No.
I mean, internally, there will be some rules that you will follow.
Internally, we'll have some guidelines, and over a period of time, some thing will emerge. It will be more in terms of the experience gained.
So, another thing is that as far as we all have known Sebi, there is only two ways for Sebi. Either you reject the application of consent or you accept the application. There's no rule to return the application. So it has been widely reported everywhere that this NSE's application of consent was returned. So can you throw light on that, whether it was returned or rejected?
It was not returned. They have filed a consent application now, and we'll consider that.
No, earlier also.
I have no idea. I have no idea. You have any idea?
It was returned.
It was returned.
Actually, as per the earlier rule, if there is some other thing is pending, so it has to come together. So they made an application for one settlement. So that was pending. That's why it was returned. It was not rejected.
Yeah. So
Hi sir, couple of questions.